Chief Justice Andrew Bell has warned that AI is moving faster than corporate governance can keep up, raising urgent questions for company directors. He says boards now face uncertainty over how existing legal duties apply when AI influences decision-making. At the centre, the issue is whether directors can still properly understand and be accountable for AI-driven advice. Let's get more on this from Darren Woolley from Trinity P3. AI is everywhere, not even governments can keep up, let alone boards. What's happening here for company directors? What do they need to know?
Well, look, it's an interesting example of the fact that government legislation always lags technology. And what we're seeing here, as the Chief Justice pointed out in his speech at Melbourne University, that AI is being embraced by companies to improve productivity. In fact, there's a lot of pressure, particularly even in the marketing and advertising area, to use AI. But what he's saying is that a lot of the protections that you would have as a director of a company may not actually cover the advice that you're taking from AI. So if you're using AI within your organization, it may preclude you from some of the protections like, the safe harbor protections of having a limited liability company or a limited listed company.
Which is interesting to watch because obviously a lot of these companies are now in a rush to try and beat each other to use AI, aren't they?
Yeah, that's right. There is huge amounts of pressure on people within organisations to actually improve productivity. We've seen some massive layoffs occur across all industries, but particularly the tech industry, which is saying that AI is improving productivity and therefore they need less staff, less employees, and then saying, well, this will help with profits. All to play to the share price. And we're seeing two of the big AI companies are lining up to go for their IPO, which I know Wall Street is very excited about. But what it means is that the directors of these companies of all companies using AI, need to be particularly cautious in Australia about how protected are they. And it's not just an Australian issue because there's articles now appearing saying that governance has become the big topic, particularly in the US, where the US government has now released guidelines on AI governance, and the Pentagon has even gone as far to provide governance on how AI will be used within the US military machine.
Yeah, and obviously, like most technology, I think of boards of directors and I think of the Australia Club across the road from us here at TICKER, not necessarily the most forward-thinking people quite often, but people who are good at providing a stable, calm, historical hand. But what AI is offering to businesses now is a huge change, and many of these businesses are relying on AI, as I mentioned in the intro, for decision making, but we don't know who the responsibility then lands with. So do you think that AI literacy is becoming a boardroom necessity, the way that maybe 10, 15 years ago, workplace laws and responsibility about workplace laws after the Fair Work Act was brought in became a huge learning experience for boards?
Yeah, absolutely. And a good example of that is reasonable reliance. Board directors are reliant on getting professional advice from accountants, from lawyers, from consultants, even from their own management team. And that is a protection for a director, that they're relying on that reasonable reliance on that advice. What the Chief Justice was questioning was, can we say the same about advice that's coming from AIs? If someone within your team is actually making a recommendation to the board that's largely been generated by an AI, does that still get covered under this reasonable reliance? And the lawyers are saying, no, it doesn't, because unlike a person giving advice, if it came to litigation, then that person could be called into the court and explain why they gave that advice. But an AI largely is a black box. And how do you interrogate a black box and an algorithm as to how it came to that recommendation? And I think that's a prime example of where board members, directors of companies all have to start being aware of the fact that just because you can use AI doesn't mean that you can necessarily rely on it when it comes to the governance of your own company.
One of the lessons that I stick to with journalism and the rules is always be careful of the person telling you the news or the history as well. And lawyers giving advice about AI giving advice, surely lawyers have their hand in the till here as well. And so too would the Chief Justice, because the last thing they want is for people to turn to AI instead of asking them for their advice. Is that something we need to be wary of here?
Oh, absolutely. And we've seen some major consulting firms get caught out relying on AI, only to be caught out on the fact that it's made a lot of it up. The other interesting thing was the Chief Justice didn't actually give advice here. He used his speech as an opportunity to lay down a whole lot of questions for boards to answer. And that's quite a strategic position, because he may find himself actually sitting in judgment on future cases, saying what he believes is the interpretation at this stage. So very much leaving it open to boards. And the question is, do you really want to be in court in front of the Chief Justice at some point in the future, trying to say, oh yeah, but I know you warned us, but I'm not really sure, it's not a good defense.
Darren, if ever I am, I'm bringing you with me, because I'm just going to blame you. Now, advertisers are still grappling with significant transparency issues in media agency dealings a decade after the K2 report, as complexities in the evolving media landscape continue challenging oversight efforts. Darren, talk to us about the concerns advertisers have regarding agency transparency a decade after this report.
Yeah, look, and this is a big issue. We're talking about $1 trillion business globally, many billions of dollars in Australia, and yet 10 years ago, the lid was blown off the fact of there was a lack of transparency. Agencies were caught out, not just with the commission that's been around for 100 years, but they were also getting kickbacks that they weren't declaring to their client. That's 10 years ago. Today, what the Association of National Advertisers in the US has found in a follow-up study is that it's become even more complex. And that's primarily because of principle-based media trading, which is where agencies are not acting as agents, but actually buying media inventory and on selling it to their clients without actually declaring what the markup is. And so what's happening is it's become a lot more complex. A lot of marketers are still struggling with it. A lot of them are saying in this research that they really aren't comfortable with it. And yet, it's been revealed through court papers that in 2024, WPP, one of the big holding companies, made $1 billion profit from this principle-based trading and kickbacks, or kickbacks is the best way to put it. So it's a big money spinner for the big holding companies, and yet marketers are largely still playing catch up here. And when we're talking about billions of dollars in media expenditure, you would hope that a level of professionalism would come to the fore to actually make it far more transparent, so that they can make solid decisions about where that media money is going.
At a time where companies are looking to cut back on their marketing budgets as well, to think that advertising agencies are still carrying on, obviously taking a clip themselves of what they're then spending, means that it could be the way that these advertising agencies are surviving, but it's almost as if they're helping to lead to that big question mark a lot of businesses have when it comes to advertising, which is ROI.
Yeah, and look, let's use a metaphor here. Think of a great chasm between the media owners on one side and the advertisers on the other. Effectively, what's happening today is the agencies and the ad tech companies are building themselves as a bridge between those two and acting as a toll booth. They're taking a clip of the ticket both ways, both from the advertisers and the media owners, without necessarily adding any real value. They're not creating value here. They're actually just clipping the ticket on the way through. And I think that, big advertisers need to really think about what is the actual amount that this is costing them that's not making it through to the media owners and ultimately getting them the audience that they want.
All right, Darren Woolley, appreciate your insights as always. Thank you.
Thanks, Ahron.